It is worth noting that my dialogue with the agency, which focused on good administration rather than simply on complying with the legal rules, is not something which the courts can do. This is a clear difference between the Ombudsman and the courts. The example illustrates well how the Ombudsman's focus on maladministration rather than on requests of strict legality brings added value for citizens when compared to the system of judicial review. I hardly need to add, in a room full of transparency experts and lawyers, that the Ombudsman services are also free, fast, and flexible. These may be factors which citizens may also take into account when deciding whether to bring a case to the Ombudsman or to actually go to court. The adoption of Regulation 1049 was a milestone in the development of transparency at the EU level, and both the previous speakers have in fact signalled the event and the reasons for that. Only a few years before, the EU institutions operated on the basis that confidentiality was the rule and that giving access to information and documents was a discretionary exception to that rule. Regulation 1049 enshrines precisely the opposite principle. As of its adoption, openness is the basic rule in the Union and secrecy is the exception. Mindsets and culture, however, change more slowly than laws. Although great progress has been made, I do not consider that the administrative culture of the institutions has yet fully come to terms with openness as a basic principle. I am nevertheless convinced that as a result of the regulation, the public's ability to monitor the exercise of power by the Union's institutions has perceptibly increased. The regulation empowers citizens in relation to the flow of information to the extent that it makes it possible for them to take the initiative to obtain information in its original context that has not yet been put into the public domain. Moreover, the quality of the institution's systems for managing and retrieving information and documents has improved, thereby enabling them to operate more efficiently and effectively as well as more transparently. The implementation of the Lisbon Treaty and of a legally binding Charter of Fundamental Rights should mark a further step forward in terms of increasing transparency in the Union. As you know, and I'll just say a few things that may overlap with what Mr. May said. As you know, on April 30th, 2008, the Commission put forward a proposal to amend and replace Regulation 1049. And these discussions, as you heard, are still ongoing. It is essential that any revision of Regulation 1049 should be a step forward for transparency and for European citizenship, not a step backward. Any reform of the regulation should be guided by what I believe was its original objective, that is to say, facilitating the widest possible access to documents held by the institutions so as to enable citizens to scrutinize and participate in processes of governance at the Union level. The Commission's proposal to revise the regulation contains a number of very welcome changes, and I have applauded them in public. At the same time, as was already alluded to, it has been widely criticized by many, including myself, for moving in the wrong direction in some important issues, thereby restricting rather than expanding access to documents. One argument put forward by the Commission to justify the proposal is that citizens for whom the regulation was devised rarely make use of it. To me, this betrays a fundamental misunderstanding of the purpose of transparency, which should lead to a change of culture within the institutions and to a more open and accountable way of working. The European Parliament adopted amendments to the Commission's proposal that I'm happy to report seek to expand access. I very much welcome Parliament's position. The most important development since the Commission presented its proposal is, of course, the entry into force of the Treaty of Lisbon, and you've well described the whole scenery there. It would be contrary to the announced objectives of the Lisbon Treaty to do anything other than to improve the level of transparency and accountability in the functioning of the EU. That is specifically in reference to the provisions now for engaging in dialogue with civil society, therefore obviously advancing the frontiers of transparency, and this is what I'm alluding to. The Lisbon Treaty also introduces a legal right to good administration. This is of central importance to our discussions this evening. Even if the rules of public access are excellent, citizens cannot enjoy their rights in practice unless these rules are also well administered. The fundamental right to good administration is included in Article 41 of the Charter, it states inter alia, and I quote, that every person has the right to have his or her affairs handled impartially, fairly, and within a reasonable time by the institutions, bodies, offices, and agencies of the Union, end of quotation. I want to lay stress on the words within a reasonable time. I regret that the Ombudsman's experience is that the Commission in particular too often fails to respect the deadlines established by Regulation 1049 for dealing with public access requests. Even worse is the Commission's performance when citizens complain to the Ombudsman in access to document cases. The Commission is creating a systemic problem in incurring these delays. It is depriving citizens of their fundamental right to have their affairs handled within a reasonable time. A systemic problem requires systemic solutions, and it is not for this reason that I consider that one effective way of tackling it would be the appointment in the EU institutions and bodies of information officers, by analogy with data protection officers that already exist in them. Another systemic improvement would be to take steps to ensure that documents are drafted with a view to ensuring that citizens, organizations, and businesses can have the widest possible access to them. Less time would then be needed to deal with applications, fewer confirmatory applications would be needed, and the Commission would be better able to respect the deadlines in the regulation. At the moment, when dealing with complaints about refusal to disclose a document, I often have the impression that no one thought about public access when the document in question was being drafted. Or, if they did think about it, they did so defensively with a view to avoiding rather than facilitating public access. A third systemic improvement would be to make it unnecessary even to submit an application for public access by providing a useful online register of documents and ensuring that the registered document is readily available through a link. This way, the citizen can obtain the document directly without having to make an application for access. The EU institutions already make a vast number of documents accessible online, and that should be both recorded and applauded. But mere quantity is not enough. The good administration of access to documents involves making available the documents that people actually want and organizing their availability in such a way that they can be found easily. This is particularly important as, in fact, the amount of information grows exponentially. And therefore, citizens are confronted with huge numbers and quantities of information, and how to make head or tail of it becomes important. The creation and maintenance of such a register is an essential aspect of genuine engagement with citizens. Such engagement should be seen as part of the core business of every institution designed to fulfill the Union's promises of transparency, participation, and good administration. I will continue closely to follow the debate on the revision of Regulation 1049 to ensure the best possible outcome for citizens. Any attempt to reform the regulation should build on the momentum towards greater openness and not to reverse it. More generally, the Ombudsman will continue to encourage citizens to make use of their right to complain to him about maladministration. In so doing, he will endeavour to make his modest contribution to the enhancement of the rule of law and to the improvement of the quality of democracy in the EU. I believe I am within my 15 minutes. Let me say oortekst, two things, particularly because I'm very grateful for the presentation by Mr. Mace as concerns the Commission. And this is not to discriminate against the Council, it is because the Commission is our biggest interlocutor in this area. It is important to point something out here. Mr. Mace works for the Secretariat General. It is the Secretariat General that, in fact, does the major work in trying to deal with confirmatory applications and does the major work in coordinating the Commission's policy and positions on 1049. And I, as Ombudsman, I'm very appreciative of the efforts that particularly the Secretariat General is trying to do in that direction and trying, in fact, to pull together the often divergent views that emanate from different kind of DGs. So I want to go on record of that. Last week I had a meeting with the entire College of Commissioners and with President Barroso, and I was particularly pleased to hear the Vice President responsible for institutions, Mr. Maroš Šefčovič, comment from his authoritative position as Commissioner for these issues. on the fact that the Commission recognizes that the Ombudsman, of course, is very often critical of the Commission, as is his role and responsibility, but that he does so in compliance with principles of good administration, meaning he does so fairly and impartially. So I want my comments, in fact, to be understood as having been said and offered in this kind of a light, and I'll be happy to answer questions on my comments afterwards.